All right, good afternoon, good morning, good evening. Thanks for tuning in. My name's Chris Baroni. Today I'm going to go over a few things with you. I'm going to go over the final decision made by the court, briefly kind of go over what's going to happen next, and then I'll give you some thoughts on the final decision. So, as many of you know, wasn't a surprise after the judge's tentative decision, and I do want to clarify this. I don't think that the judge wrote the tentative decision. In fact, I know she didn't, but she did sign off on it, so she owns that decision. I have been asked, and I think I've mentioned this before, the decision was written by, quote, the law clerk, but the truth is the decision was written by Tom Ware's law firm, okay? And then he gives it to the law clerk. The law clerk then, maybe changes it up a little bit and then gives it to the judge, and then the judge goes ahead and puts her initials on the bottom. And that's why, like when I showed you guys, this is Shirley Watkins, signature. Normally when I print stuff out and I put it in my name, I don't put my signature on the bottom because people know I did it. That is your true sign. And by the way, it's not even uncommon for judges not to write their own decisions. What is a little bit weird and probably conflicting is the fact that I know that the plaintiffs wrote it. Okay, so the question is, can I prove it, right? Well, we'll find out. The problem with the decision is there's several, okay? So the first problem with the decision is the Lakeland Area Homeowners Association had no standing to bring this lawsuit against other directors. That's first and foremost. The judge completely ignored it. No matter what she says, she ignored it. It's in writing. It's in the transcripts. That was irrelevant to her, and it actually is irrelevant. But hopefully, the appellate court finds that it is relevant. The next part of it was that the association has an obligation, right? And I want to make sure that you guys understand when I say this, has an obligation to provide legal counsel to its directors, okay? They did not do that. I did that, okay? So, and around $30,000 of that. So, why did I do that? Because it was the right thing to do. Although the judge doesn't think I'm very credible. That's funny in and of itself. But and I then represented myself because the judge pretty much said I had to. And not even saying it was good or bad, but that's what she said, and I don't think it's her place to even be making that decision, not even for the court. Okay, so that's a couple of the problems. The next problem I think that I have, especially with this decision, obviously besides the homeowners not being a part of it, which was never voted on, it was never proceeded with, never provided to the court, no legal counsel for the defendants in this case. The big issue that I have is the blatant dishonesty by Judge Watkins. And listen, I will say this to her. I will say this to anybody. I'm not trying to be disrespectful. I'm just simply stating facts, not opinions. That wasn't an opinion. That's a fact, and I'll explain. She did not permit Tom Ware to be a witness, period. She lied in her final decision, period. Okay? The inspector of elections has to be chosen by the association, period. It was chosen by Michael Allen, period. There was no denial of the request from that was sent to the board to choose the inspector of elections, period. It was never testified to. There's no evidence to prove it. Same goes with the sending out of ballots. Michael Allen did that. This conflict of interest being ignored by the judge is mind-bogglingly bad, period. That was an opinion, by the way. But come on, I mean, it is a conflict of interest, but I'm not an attorney, I'm not a judge, so I'll let that go. But let's be honest here. Okay, so the other thing is, of course, she failed to address, as did Tom Ware, understandably so, my objections. I get it. Because if 5034 is the controlling document, you can't have Section 11 of the bylaws then control it and control it erroneously, okay? The reality of the situation, and Davis Sterling makes it very clear, that it takes a majority of the association to approve a recall, okay? To approve a recall. And then you can tally up votes, okay? There is no reduction of a quorum. That would be, and this is going to be an opinion now, asinine. Because what the judge stated clearly, although not to you guys, but is if you use the, I guess, the process for which wherein the judge agreed on, 58 people, listen carefully, 58 people can overturn 459 votes. And you have 3 directors on the board. We're real happy about that, okay? One of them is Harriet Cohen, who took herself off of a lawsuit, right? Or took the association off of a lawsuit against her. And her attorney, Warner, was it Keith Warner, I think, something like that? He should be proud of himself. And it was taken off, I think, right away. In fact, we have the legal recording and legal transcripts of that, which will be very admissible and important in our case, as it will be throughout. The 3 directors didn't even file the lawsuit. In fact, since the election wasn't really validated, or now it is post-dated, only 2 directors would have. Why wasn't Hal on there? Okay, my guess is because Hal's attorney is ethical. That's my guess. He knew that wasn't one that he should be getting his client involved in. Then you have that minimum requirement for the recall that was never met. Then you have the legal opening of ballots. And that's a problem, right? Because now you're exposing votes to people who they had a right not to have exposed, right? By a League of Women Voters who had never ran a recall before. By a guy who couldn't prove that he even sent out 459 ballots. Okay? This isn't it's a decision that is curious, to say the least, because I think that the judge is very capable of understanding what the requirement was for the recall. To that note, the fact that Judge Watkins was the one that probably assigned herself to this case also demonstrates, at least gives the impression, and I think it does demonstrate, at least, but I'll say that's my opinion. If I was to try to speak more objectively, it lends itself to giving the opinion that the judge shouldn't have taken this case because of the plethora of cases that she's already representing the HOA on, or not representing, but overseeing, and that it's clear from her decision and her demeanor that she was tainted in this ruling in and of itself. So, I looked at the recall and election coming down to basically 3 important things. First one is was the minimum requirement of people to participate in the recall present? And the answer to that is unequivocally and undeniably no. There wasn't 230 people. And by the way, because if you're going to throw out 150 or 100 votes or whatever the judge threw out here, which is really bad, you'd want a majority of the people to have agreed with that. Instead, she has a super minority of the people who agreed with that. You don't accept super majorities, but you accept super minorities, okay? It's bad logic, it's bad law, and it's very tainted. It's bad. I'm just going to say this. There are attorneys who are a lot smarter than me when it comes to the law that know and have said what I'm saying in far worse words, okay? This isn't, and I say this before, this is not a cookie. This is not a cookie, okay? I may be hungry and want to eat it, but this is a phone. What the hell does that have to do with the decision? It's the same thing when it comes to the requirement for the recall. There isn't another thing we can call this, and certainly we're not calling this a cookie, okay? It's always going to be a phone. The requirement's always going to be half. You can't patchwork things in and out, say, well, Corp Code 5034 is the controlling document, but we're going to take little sections of the bylaws, and we're going to go back to another corporate code, then we're going to take a little more of the bylaws, and we're going to put this in a stew, and we're going to create the illusion that we have what we need for the recall. And as I correctly identified, this should never have been brought to the court as a validation of an election. Not unless you can validate the recall first. And clearly she didn't do that. And she knows that. On top of that, the most important thing when it came to this, and obviously I, went through a lot of, time and effort to try to, better understand it because I had to, is that minimum requirement was the process for which the recall and election followed lawfully. And so we'll get to that. Again, I think I mentioned this. There's only the association can send out the ballots, and only the association can send out or choose the inspector of elections. Now, it was never denied, and Michael Allen did it all on his own, and nobody knew, including Harriet or Hal, that he was doing that, okay? So you know that. That's testified to. That's in the transcripts. A more reasonable and honest opinion on that would be, you can't, whether you like it or not, do it on your own because it's not the association. The law doesn't provide an opportunity for you to take it upon yourself to do it. Now, while the judge may have some discretion with regard to that, and I believe that's what she's using to make this ruling, that's questionable too. So whether the appellate court will agree with that, I don't know. If we have to take it to the Supreme Court, then fine. Because I promise you I'll do all of it. The only thing necessary for evil or tyranny to succeed is for good people to do nothing. And yes, I did change that up a little bit, but it's the exact same premise, okay? Edmund Burke, by the way. And then I know there's going to be some scholars out there. Well, he was in it. Edmund Burke will be credited with that one while I repeat it. The point being is the next part of that is, was the election validated, certified? Okay. I can't express enough that if you're going to allow ambiguity regarding a certification, the ambiguity, in my personal opinion, should be predicated on what was really presented. Okay, if they just simply forgot to put validation of an election on top and they put summary votes, but they did all the things that you do on a validation or certification of election, then fine. But we didn't have that. We didn't have anything that resembled that. And the reason we didn't is because the League of Women Voters was actually smart enough not to do it, right? Because if they do, and as we appeal, and then if we decide to sue them, or bring them into the lawsuit, they will, I promise you, they will use that as justification that they didn't certify it, okay? The judge knows that. The judge doesn't care. The judge is quite frankly tainted, and that's why the decision was made the way it was. Now, was my objections hard? They were exactly in line with the attacks that were put on myself and 3 upstanding men who volunteered, as I did myself, for 9+ months. And then, let me just put it to you this way. People go, oh, you were getting paid. Nobody else dropped their salary by over 30% in order to take this job. Okay. So I'm still saying I volunteered. In fact, I'm saying I paid. Okay. So I know this idea that I was actually making, money there. No, I was losing money while I was doing this job. Okay. And a lot of it, and still they haven't paid me back on a bunch of it. Okay. Keep that in perspective, because it's at least important to understand. And that lack of a validation or certification to oversee that and not even see the tally of votes. And, you have to have on the certification what the quorum was and how it was met, right? The reason why they didn't have it, and the reason why it's not there, and not there the way it should be, is because if they were to have put it there, they would have been patently wrong. It's actually not a bad thing not to have put it there. That's why it's not a certification. It's not because we're trying to find a little thing here and a little thing there. No. It's because look at the certification or validation that we had from the others. It's pretty clear that they did that, okay? Last but not least, and this one is really going to hurt the judge. And because she validates, ironically, my argument in the end, which is on March 11th of 2019, Judge Watkins dismissed a case, and I think it was like Rappaport GPL versus, it's the same, by the way. Rappaport didn't even file it. And I know he's pissed off that I probably said that, but listen, I wouldn't lie to him, and not going to lie to you guys as far as how that all went down. Rappaport never filed that lawsuit, and there's nothing that will say that he did. If anyone wants to question me on that, I can prove it. Hence that will be part of the conspiracy and the things that we'll be moving forward with. That being said, though, and same thing with the Osteria Orto shit. We know who filed that. David Smith did. Okay, or financed it. Anyway, bottom line is, which by the way isn't illegal to finance that, but if it was just the one thing. The decision on March 11th of 2019 that dismissed the motion or the lawsuit or the request from the judge to bring kids are crazy. It's like music to my ear, though. The thing is that she dismissed it because they didn't provide election rules, and the judge made a very bad, like it was great when I read it, decision at the end when she said, well, hey, listen, we didn't bring, so she said that in 2019, which was almost a year, it was 2 days before our trial ended. So it was almost a year to the day that they didn't, the plaintiffs in the case, the moving party is what she said. The moving party didn't bring the election rules, and in order for her to have been able to rule on anything regarding the recall or the election or any of that, that she would have needed the election rules. Well, this multi-million-dollar conglomerate law firm with Tom Ware and, and Siegel and whatever the hell the rest of their names are, couldn't even go back at the time when they filed it. It would have been, 10 months, and saw what happened there. Probably because they knew they didn't want the judge to see what the election rules said. Bottom line is, the judge ruled that she could not go through with the election or with the assigning of a judicial observer or handler of the election because they didn't give her the election rules. And so at the very end of all of this, when they arrested, we provided the election rules. And then in my arguments, I stated, hey, listen, you already ruled that you can't do this stuff without it. So instead of just agreeing and, having the courage to make the right call, she decided to say, well, hey, listen, and I'm paraphrasing, of course, that you guys didn't provide this. This wasn't a part of the initial argument, and therefore, I can't really rule on it. Well, guess what, Your Honor? It wasn't provided for you in the first one either, and you ruled anyway. Good luck reconciling that. That's it. That's all I've got to say. It's been long enough. Just wanted to give you guys a heads up on all of that. And that's it. But if you have any more questions, feel free to shoot me an email, and talk soon. Thanks.